Olin
What was your
Owens.
name? Okay, and Miss Estabrook, your name for the record?
Lori Estabrook.
All right, and guys, I want to thank everybody for appearing via Zoom today. And please realize, even though you're appearing remotely, this is a legal proceeding, just as if you guys were all here and present in the courtroom. Mr. Owens or Miss Estabrook, any questions for myself or counsel regarding that this is a legal proceeding today?
No, sir.
Okay. All right. So, Mr. Owens, who did you send a copy of your motion to?
To Lori Estabrook.
Okay. So, and we'll cover a couple of things here. Maybe we can resolve this, maybe we can't. So when somebody is represented by counsel, you cannot serve the other party. You have to serve the attorney. So you would have to mail that to Miss Lindquist's office because she's the attorney of record. So that might be something you didn't know, but from now on, you send everything to Miss Lindquist, not to Miss Estabrook, because she has an attorney representing her. Now, your motion is only one sentence. Your motion was blank, and the notice of hearing just says, to see my daughter that is being kept from me unlawfully. And then it said you have called her on August 1st, 2nd, 4th, 5th, 6th, and 8th.
I've called her many more times.
Okay, but I'm just reading your notice of hearing.
Right,
But you
right.
did not write down, so, okay. So there's a couple of things. In the motion, just instead of filing a notice of hearing, you're supposed to file a motion and indicate specifically what you're asking for, meaning the schedule, custody, parenting time, and what you're asking for today and why. So that would you'd probably put in there, we were together, we broke up, we followed a schedule, we didn't follow a schedule, this is what we did. Now, Ms. Lindquist, on behalf of plaintiff, they also have a motion that they just filed on the 24th for September 11th for custody, parenting time, and support of your minor child who's 7. Is that correct?
Yes, sir.
And what's the name of your guys' child? Okay, so there's a couple options here. I can adjourn this a week so everyone can exchange everything. Or if you guys want to waive defective notice, meaning Mr. Owens, you probably have not yet got her motion in the mail either, that they just filed on August 24th. Have you got that yet or no? Probably not.
No.
Oh, okay. So she has another motion filed regarding pretty much the same issues. And while it's not titled the same, you both need a resolution on a temporary basis on custody, parenting time, and support, and realize that this is only temporary because you guys have a right to go all the way to a trial. So there's a couple options. I can either adjourn it so you can get proper notice, which is 10 days notice. That's for everybody, 10 days notice by mail. It's now e-filed. So if you sign up for the e-file, it's faster. Or you guys can both waive defective service with Ms. Lindquist knowing that you really filed a blank motion and just said, I want to see my child who's being kept from me. And I can very quickly read through and I say Ms. Lindquist, but I mean, it's plaintiff's motion prepared by an attorney. I don't want to act like this is Ms. Lindquist litigating this. She's the attorney. Or I can read through this. It's 2 pages and indicate verbally what their motion says, and we can address them both today. You wouldn't have to come back on September 11th. And whatever I do today, you guys have 21 days to object. So you both could say, we waive defective. Yours isn't defective. It's just, it hasn't come up yet. I'm speeding it up because they scheduled theirs 10 days after they filed. But if you guys don't want to take another day off of work or come here, we can do it all today if you guys agree.
I just want to be able to see my daughter. I just want to be able to see my daughter.
Your Honor,
Okay,
this motion is pretty complicated, so I don't think at this point we want to waive notice. We would just like to proceed September 11th.
Well, his is blank. He would be, I mean, it's more detrimental to him to not hear yours. I mean, if you guys are ready to go forward.
This is completely defective.
Okay, so let me do this. So we know that Mr. Owens is basically one sentence that says, I want to see my daughter who's being kept from me. Mr. Owens, I'm going to read through counsels. If at that time you still want more time, don't want to have this heard today. For instance, you might want to talk to family friends. You might want to talk to an attorney. I will then still, if you decide you don't want to go forward, I'll let us adjourn this and hear this in a week or two.
Well,
Because
see,
okay, go ahead. Go ahead.
My problem is I'm an actual I have bills to pay and stuff, unlike the plaintiff, and I don't have money for 2 attorneys like she does. I just want to be able to see my kid.
Okay, yeah, but you got to take one thing at a time here. I understand what you want.
She's keeping my kid from me over furniture.
Stop. You gotta listen to me, sir. So you have something you want to hear, but there's also procedure and notice requirements and how you have to prepare things. I get that you guys want to resolve
procedure when they came and took my kid.
Stop, Mr. Warren, you got to take a breath. You got to listen to me. I'm trying to get you there. You got to listen to me. I'm going to read through her motion and have you decide if you want time to prepare and hear it on the 11th. But if you want to go forward, because you guys are both here for the same thing and you're willing to waive proper notice, both of you, we will go forward. I'm going to read what you're going to get in the mail shortly. It was sent out on August 24th. This is what it says. Please don't interrupt me. I'm just reading through their motion. So some of this is basic stuff. The plaintiff is a resident of Macomb County, has been for 180 days. You guys are both residents of Macomb, is that correct?
Yes.
Okay, so we got that covered. Parties have never been married. You have one child who's 7. She lives in Macomb. And sir, what city do you live in?
I live in Clinton Township.
Okay. And then it says she's a fit. Okay, and it says she's a fit and proper person to have custody. These are pretty standard things. And then it says they like a temporary custody order. At the beginning of a case, parties usually need to have that determined while you litigate. So you know it doesn't mean it may be the final thing because you have a right to investigations, hearings, and eventually a trial. So I would suggest you guys, so hers is a general motion to resolve temporary custody and parenting time pending the litigation, which is what you want to. I would suggest you guys proceed today so you guys can get some resolution and you'll still have 21 days to object to whatever I do.
I want to proceed.
Like to go forward?
Yes, I would love
Your
to.
Honor, I don't have availability in my schedule today. I'm booked very solid and I'm not prepared to litigate this today.
Oh, wow.
So you don't want to move up your motion?
No, I'd like for
that
for the 11th as scheduled.
No.
I would have had a different slotted time if I knew.
If I adjourn his, it's not going to be the 11th. It's going to be next week.
That still wouldn't be proper notice. 10
for
days
him.
notice.
Well, he served her, not you. I mean, technically, ma'am, did you get his motion? It's blank. I mean, Ms. Estabrook.
What did you say?
Did you get his motion that he sent to you?
I just got it in the mail the other day.
Yeah. So he's new. He doesn't know litigation. He served her instead of counsel. It's pretty much blank. And what I don't want to have happen here is a stall tactic over which time he's going to be completely and have no ability to see his child.
Or speak to her.
I
spoke to her in a
let
month.
him have like an hour at Phoenix House if he wants in an interim, but I wasn't prepared to litigate today because his motion was filed so improperly and I have an afternoon already scheduled for me. Like I didn't even have notice of this. I had no idea until Thursday.
Let me ask a quick question. How long has it been, sir, since you've seen your daughter, age 7?
I wasn't allowed to go to her birthday party on the 29th.
When is the last? When is the
29th? The 29th.
The last time he saw her was the 31st.
And ma'am, is there a reluctance to have contact between him and your daughter?
Yeah, because he held her diabetes receiver hostage for 3 days when she's a type 1 diabetic and it's life threatening.
No, I did not.
The police.
They stole her from me.
Mr. Owens, guys, let me be clear here. If you guys cannot behave remotely, all future hearings will be in my courtroom so I can have a deputy here.
I wish they would be.
Mr. Owens, you're not listening to me.
I'm sorry.
If you were standing in front of the courtroom, you wouldn't be yelling and screaming at the other party when they're talking. You have to take turns. If everybody starts yelling, guess what? This is what I say to people. If I walked into your employment and I started yelling, I might have something valid to say. It would be hard for you to listen to me because I'm yelling at you. And you're not going to want to hear me because I'm yelling at you.
You're
all
right.
have a want to say, but you cannot say it at the same time. And the nature of litigation is someone may say something that you don't like. You think's a lie. You think it's exaggerated. You think it's minimized, but it's a court of law. You got to stop and wait your turn. So when I'm talking to each one of you one at a time, you cannot yell over each other and say, so I'll get there. I've done this 25 years, guys. I was a private divorce attorney before I came to work for the court. I've been on both sides of the courtroom. I can listen to facts one at a time. I appreciate that. So we started out as, what is the last time? I said, realize her attorney is hired to zealously represent her. That means she's there for her, not for you.
Oh, I know.
She's representing what Miss Estabrook has advised her of. So I just said, why have you not seen your child in a month? They said you kept her and did not give her diabetic medication.
No.
You now are yelling, saying you don't agree with that.
No, they came and stole her from my house the day of her birthday party, told me, had called the police, told me I was not allowed to come to her birthday party, that Miss Estabrook's Miss Estabrook and her boyfriend now have herpes. I don't want her boyfriend around my daughter because she is a type 1 diabetic, and that's a compromise to her immunity. This is fact. This is not exaggeration.
Okay, so stop. So Mr. Owens, if you're arguing for custody and parenting time, you needed to not file a blank motion. You need to put.
I didn't know what I was doing. I've never done this before.
I understand, and that can be.
I'm a single father who pays rent, who pays car payments, who pays everything. I don't have money for a lawyer.
How you don't have to get an attorney? I'm trying to talk to you right now. I'm saying you have to get an attorney? No. So Miss Estabrook, stop. Miss Estabrook, give me a little light on what's happened here. When's the last time he saw your child? What were you doing before he stopped seeing her? What's been going on?
I can walk you through my motion, which gives a pretty good background.
Okay, if you could do that. I know counsel, it's frustrating. You like it adjourned, but I'd like to get a little feel for. I may maintain.
I know
no contact, but I'd like to get a little feel for what's happened.
I'm just scheduled at 2:00 to be somewhere else, but.
Okay, well, I'll resolve this I promise I'll resolve this by 2.
Okay, thank you. Defendant had been exercising parenting time every Saturday overnight with the child. He has a history of heroin use. On July 28th, he started exhibiting some erratic behavior. Friday, July 28th was when he was supposed to have parenting time in lieu of his regularly scheduled Saturday, as the plaintiff was having a birthday party for the child. He was invited to the birthday party, but he indicated that he could not go because he would beat up her boyfriend if he saw him. So he ultimately on Saturday said he wasn't going to return the child, but they were ultimately able to get her back. My client again allowed him parenting time on Sunday, July 30th, and on Monday he refused to return the child. With the assistance of the police, the plaintiff and her mother were able to retrieve the child. However, he refused to return her insulin receiver. She's a type 1 diabetic, and not having the receiver can be life-threatening. My client has an app on her phone that attempts to do the same thing, but it does not have the same alerts as the receiver. She missed numerous alerts, and it was 3 days that he held the receiver hostage before he finally allowed the plaintiff's mother to retrieve it from his home. 3 days without her insulin receiver. He also, in July, he was arrested in the city of Detroit. He called my client 16 times from the Detroit Detention Center saying he was arrested for drugs. Upon further review, his criminal records attached. He was sentenced on a felony controlled substance charge in May of 2023 and is on probation for that. And you can see the text messages attached. He acknowledges that he's an addict. He says he is addicted. She has no idea what it's like to be addicted to something, is the nature of the text messages that are attached. And
I'm sorry, counsel, what are they? Oh, I'm sorry, I'm looking at the wrong. This is why I'm looking at the wrong thing here. Okay, go ahead, counsel. I'm sorry.
Since the incident occurred at the very end of July, the minor child has now indicated she's scared of her father. She has had is not normal for a 7-year-old, and historically a psychological problem. And when the plaintiff has allowed the defendant to have contact with the minor child over the phone, he spends the entire phone call bad mouthing my client. So
Okay, go ahead.
So he's clearly dangerous. We're asking that his parenting time be at Phoenix House. He clearly needs some sort of substance abuse evaluation. And he is gainfully employed, not paying any child support. And we're asking that support be effective our motion filing date. Parties communicate through app close, and that the court enter a parental cooperation order barring the defendant from speaking poorly of my client to the child.
Okay, I don't want anyone to speak right now. Nobody speak. And when I ask somebody a question, I only want that person to answer. So Miss Estabrook, how long had Mr. Owens been doing Saturdays to Sundays?
Doing Fridays and Saturdays, and then I don't remember exactly when it was, but he decided he was picking up extra shifts at work, so he could only take her on Saturdays. He would pick her up at 3, but I don't remember the exact date that started.
So are we talking weeks, months, 1 month, 5 months?
Months.
How months? 4 months,
Like
6 months, a year?
6 or 7 months, 8 months, something around there. I don't
So
remember the
6 to
exact
8
time.
months. So 6 to 8 months he was doing every weekend. And was
One
everything
day.
going okay? Was everything going okay?
Saturday to Sunday, not the whole weekend.
Yeah,
Okay,
it would be
I
pick up
got guys,
Saturday.
I got it. I got it. Was it going okay for 8 months until this recent incident?
Her sugar was high whenever she's with him. Her numbers are ridiculously high. She says that he's gone at the store for a few hours at a time. But him and I would be fighting and arguing.
Over what?
Just everything and anything. I can't have my boyfriend around her, just stuff like that. It was constant arguing.
And okay. And Mr. Owens, what were you arrested for in July?
I wasn't arrested in July.
So when they say in July you called her from the city of Detroit and indicated that you were in the detention center, when did that happen?
No, I was never charged with anything in July.
I mean,
So Ms. Estabrook, is that wrong or is that right?
Look
he
up
has
my
the
record.
call logs. I mean,
Look up my record.
I don't want you guys, when I talked to one of you, you answered. You said I wasn't in July. Ms. Estabrook in her motion said you were. I want her to tell me if it was July or not, or if it was May.
It was July. I think it was July 11th or July 13th. I got 16 phone calls from him from Detroit Detention Center telling me that he got arrested for possession and that he also got charged with fighting with the cops. And I have the call record showing that he called me from the Detroit Detention Center.
So, sir, do you remember, does this refresh a memory? Did you get arrested for resisting arrest and some other issues?
No, absolutely not.
You do know I
Absolutely
can
not.
ask you do know I can get a copy of your leave as the court.
Yeah, I wasn't charged with nothing in July. I got charged in January 11th of this year, 2023. I was on heroin. I was on heroin from the time I met Lori, from the time we first got pregnant, she had an abortion, till the time I had my daughter. I just got clean July 11th when I got discharged. I've been clean ever since, but it was never a problem when we were together.
Stop. Wait, you just said I got clean July 11th when I caught this charge.
I mean, January 11th. I'm sorry. January 11th. I bought my car February 12th because I was able to save money. I've been doing great.
If she has phone records from the Detroit Detention Center in July, that's not you?
No, it's not me.
Were you picked up on a probation violation or a charge from January?
The only thing I was ever picked up on was an insurance charge, driving without insurance.
When?
I don't even remember what it was. I was never resisting arrest, never nothing like that.
And you're not using now. What if I sent you right now to Jams to get tested? Would you be fine?
Yeah, I'd be perfectly fine. I'd take medical marijuana.
Are you on probation right now? Are you on probation and dropping?
Nope, not on probation at all.
So
Your
this,
Honor,
so
he
the
is
charges
on
were dropped
probation through Macomb County
for what?
For
for the
what?
possession charge in January. So there's two different charges. In January, he was arrested and charged with possession of a controlled substance in Macomb County. He was sentenced at the end of May on that charge to a term of probation. I can pull up the register of actions. And then in July, he called my client obsessively from the Detroit Detention Center 16 times, telling her he had been arrested for resisting arrest and possession in the city of Detroit. But as you know,
Miss
it's
Estabrook,
difficult.
okay, just a second. Miss Estabrook, is there anybody in his family that you're close with that you get along with?
No.
The problem,
Nobody at
Your
all.
Honor, is he lives with his father, but his father is like not capable of supervision because he can't drive. He can't, he's disabled and himself.
All right. So guys, I'm gonna agree that if plaintiff does not want to pursue her motion today, it's scheduled for September 11th. Sir, you need to supplement your motion. Why do you think plaintiff and her boyfriend have herpes?
So she told me her mouth she couldn't talk for 2 weeks. She had all these white bumps in her mouth. She couldn't even open her mouth for 2 weeks.
Even if that's the case, why do you think it's dangerous for your daughter?
Because the reason why a lot of this started when the outbreak, the COVID outbreak came. I didn't want my daughter getting that vaccine. The plaintiff went behind my back, got my daughter the vaccine, and said because my daughter's immune system is compromised, she doesn't need to be substance to stuff like that. Okay, you know what? I understand. If that's how you feel, I don't feel that way about that COVID vaccine. But at the same time, if her and her boyfriend have herpes, which I know for a fact that they do, I don't want them around my daughter, and because she has a compromised immune system.
Well, there's
Not relevant.
Well, maybe you should talk to a doctor about, because there's lots of people who have diseases that have children, and whether their children will get it.
I didn't say nothing about Miss Estabrook, sir. I'm not saying that to keep her daughter away from her, but to keep him away from her. He's not her parent.
Okay.
He's not her parent.
Okay.
I'm her parent. And for them to kick me out of the party, they tried to say that I told them I wouldn't come. They called the police, had the police there. Police told me I was not welcome to the party.
Well, you guys can't go to each other's.
going.
You guys can't go to each other's property unless you're invited. That's trespassing, right?
Right. She tried to say that I refused to come to the party. No, I was told I wasn't allowed.
Stop. Okay, guys, this is what I'm doing today. A1. Defendant's motion is adjourned to Monday, September 11, 2024, at which time plaintiff's motion regarding custody and parenting time is scheduled. Two, defendant shall supplement his motion with specific allegations as to his position regarding custody and parenting time. So Mr. Owens, you can just use a piece of paper, write the case number on the top, write supplement to motion, write down specific allegations, and you can file those with the court or send them to Ms. Lindquist. I'm going to put in here 3. Parties are reminded that as long as there is attorney retained, the attorney must be served, not the party, not the other party. Does that make sense?
Smoking a cigarette on Zoom, Your Honor.
It's remote, it's in a car. I got a thick skin. It doesn't bother me. All right. So Mr. Owens, you got to take a piece of paper, write specifically motions. You have to say specifically the facts of what you are trying to base what you want the court to consider. You have to take a piece of paper, write your case number on the top, put supplemental motion on it. Write down all of the allegations you want to make against Ms. Eastbrook, and then indicate what you want custody and parenting time to be. Okay?
May I ask a question?
I'm going to put, just a second, I'm going to put in there 3. As this is a custody case, neither party has the right to enter into each other's household or onto their property absent an invite from the other party. I'm making this clear. I don't want you guys to get in trouble when it's unnecessary. You can't walk
That's how
in
they
each other's
got my daughter.
houses. You can't. Well, I'm saying in the future,
They
guys, law
walked in my
enforcement's there for a
house and
reason.
took my daughter.
Okay,
No, I did not.
call law enforcement. Guys,
I
you guys
did.
can,
They told me that there's nothing I can do, and I asked, "Well, can I walk in their house?" They told me no.
No,
Clinton
you
Township has
cannot.
different.
May I
Okay,
explain
I'm not-
something?
Lori,
no,
you
guys,
don't
I don't
need
need to
to.
hear it now.
Sure, it says
Guys.
she's admitting to it.
No.
Guys, listen, I'm not your local law enforcement. You guys call the police. I'm not the prosecutor's office in law enforcement. What I'm saying is, I want to make clear at this hearing, based on the nature of what I've heard, don't be entering into each other's property and entering into each other's houses without an invite, or you're going to call the police on each other and you could possibly get prosecuted. Don't do it. Call
Well,
Child
can I
Protective
see my daughter?
Services. Call Child Protective Services. If you think either party's abusing or neglecting your child, you can do that as well. Otherwise, based on faulty notice, I'm adjourning your motion to the 11th. You have to supplement your motion, and you're gonna hear their motion, which you're gonna get shortly in the mail, which is exactly what we were just talking about. And I'm sorry, counsel, when I went to say I read the motion, I read your complaint. That wasn't the motion,
Oh.
guys, just to correct the record. That's what I was looking at.
Sorry, I wasn't trying
So-
to be difficult. There's just a
So,
little
so
bit.
I am adjourning this as pleadings were defective, that they didn't state the reasons on what you were requesting. I'm going to find that service was not proper. And I'm going to put at the beginning, as service was not proper, this matter is adjourned. At the beginning of that, I would suggest you guys take a breath and calm down and talk to each other and see if there's any ability.
She blocked me from every
Okay.
capable way of contacting.
Ma'am, is he blocked from any ability to contact you?
You can call my mother's phone.
Okay, I'm gonna put stop.
Up in a month.
Stop, Mr. Owens. Listen, you gotta calm down.
This is my daughter we're talking about. I'm not
Well,
a
sir,
part-time dad.
Okay. I'm gonna put in here, where are we at? 3? 5, both parties shall submit to a 9-panel urinalysis drug test within the next 24 hours at a JAMS location and shall exchange that test with counsel and or the other party if no counsel.
Really? Wow. What about a medical test for her herpes?
It's all irrelevant.
How is it irrelevant?
I don't know.
Has nothing to do with parenting time.
Wow.
All right. So guys, you're gonna
What a
supplement those motions. You're gonna serve them on each other. If you haven't been served, effectuate service, you're gonna submit to a 9-panel urinalysis drug test. And that test shall also be provided to the court at the adjournment date on September 11th. All right, guys, you have 21 days to object. We're gonna email you a copy of this order and the objection procedure. At an objection hearing, the Honorable Terry Lynn Denny's may uphold this order or change all or part of it. And even if you object to this order, it does not change the fact that you guys are due back on September 11th, because that's the date for the motions. Okay?
So if I
You guys are all set. So guys, I can't rule on motions that are not properly before the court today. That's going to conclude the hearing. If you guys have any procedural questions on how to object, you're welcome to call my office. All right. Have a good day, everybody.
Thank you.